Before this goes any further down this hole, let's get going. All right. First bill we're going to hold. Second bill, 679.
Okay. Senate Bill 679 is a departmental bill, and as amended, you should have the amendment on your desk. It authorizes the disclosure of tax information to a person, government entity, or tax compliance organization for the purpose of assisting the comptroller in tax compliance activity. So this is about data sharing and ensuring that those individuals who are sharing data protect the data based on the comptroller's rules.
Is there a House bill on this?
Yes, there is a cross file of this bill. It's House Bill 454. And the Senate bill was amended to conform to the House bill. The amendments were worked out between the Comptroller's Office as well as CPA Association.
Okay. This is Senate Bill 679 as well as House Bill 454, both on your list. And they're both in the same position.
They're both in the same position.
All right, all those in favor? Aye. Opposed? Okay. Stallings and Jennings. Okay, and Senator Roosevelt.
I'm not opposed.
I know. So you will have both of those. Okay, one House Bill 154.
You guys do have a reprint on your desk for this one. It is different. And there are some amendments that are being offered for budget and tax to adopt. This initially
Was there a Senate bill? Yes.
There was a Senate bill.
And we passed it.
You did pass it. It's over in the House. I've shared these changes with my counterpart. I believe they're going to adopt.
So we can put it into our position. Is that what you're doing?
No.
Okay.
Okay, so this is the bill as initially came in. The first reader version dealt with the homeowners tax credit, and if you were enrolled in one of the homeowner protection program, which is the one that keeps you out of tax sale, it would give you an extra time to apply for the homeowners. As you guys passed it out, you added an amendment to do something similar for the homestead tax credit, although for any homeowner, not just those in the tax sale pathway. So there were some discussions about that amendment after the fact, and so what you have before you is a different version, although it accomplishes the same thing, which is basically on page 2 of the reprint. It basically says that any homeowner, if they meet the criteria of this provision, can get a 1-year recalculation of their homestead tax credit. Not a reimbursement, but just a 1-year kind of recalculation, so that then your current year taxes will be calculated as though you had it in the prior year. So a kind of lowering of the base if your taxes are going up. The people who would be eligible for that would be at least 70 years old, was eligible prior, but just didn't file an application, and they have to apply for the credit again. So this won't require SDAT to kind of.
You say 1 year?
I'm gonna get.
Oh,
yep,
sorry.
it's okay. So in the code would do it for 1 year because it would be codified. It would be in perpetuity. There is also a special section that would sunset.
Very special.
that would sunset after 1 year. That would provide a 2-year look back, as long as they make an application on or before May 31st of 2025. And then that provision will sunset after that date goes by. And it has a retroactive provision that goes back 2 years to make sure it accomplishes. So what happened is 2 years ago, something was changed in the homestead that I'm not going to say it was like that was interpreted differently. So if the intent of the General Assembly is to do this look back at 70 years old, this provision would go back 2 years to be corrective for that interpretation from 2 years ago. But then after May 31st, 2025, it would expire. So that's.
All those in favor is amended?
Aye.
Opposed? I know that this is a tough issue, and I know it takes a lot of thought to get into this one, so I'm going to give it to Senator Hedelman, because I know she's capable of figuring it out. House Bill 200.
Right, I believe you have a reprint on your desk for this as well. This is the community schools bill. It does not match what you guys passed over to the House, but a group of people kind of conferred offline and agreed to some middle grounds on some issues. The biggest difference here is initially this bill had the requirement that, or the authorization that for certain counties that have a certain number of community schools, that a certain amount of funding, the concentration of poverty funding, would be going to the central office so that they can spend it on behalf of the schools. Those provisions are all struck from the bill. So what's left is same report that you guys asked for in terms of how the funds are being used and the impact that it's having. And then some other, on page 12 of the reprint, some other kind of conforming changes saying that the department may provide comments to the community school coordinator on the implementation plan, but it's just review, it's not approval. And then the House had a different reporting requirement that is being struck. So it's largely the Senate version minus the spending on behalf of provisions.
Did we hear from any school systems? Whether they would go on with this or not?
Not about this version because it's like a compromise position. It's
Is it
Yeah, it seems like it.
favorable?
All's in favor? Opposed?
as amended.
As amended.
Doesn't end it.
Yes, and to my knowledge, the House will be making the same changes to the Senate bill.
Senator King, you got that one?
Okay.
243.
House Bill 243 is a departmental bill making revisions to the tax sale process in the state. This bill was not cross-filed. You do have a reprint on your desk. Brief overview, the bill is making various changes to state law regarding tax sales. It is altering the properties that local governments are authorized or required to withhold from sale. It's altering the maximum redemption rate for owner-occupied residential property. And then it's also extending the timing for the filing of a complaint to foreclose the right of redemption on owner-occupied residential property. There are a few amendments for your consideration that have come up in the testimony and some of the discussion. So if you turn to page 2 of the reprint, section 14811 in the tax property article is kind of the overview statute for when properties shall or may not go to tax sale. One of the things that is being primarily changed in the bill is current law has some restrictions on the sale of residential property. And the bill is narrowing that to, in some instances, to make a distinction between owner-occupied residential property and non-owner occupied residential property. So you see those changes on page 2 and 14.811. One other thing the bill is doing, so for owner-occupied residential property, also the threshold is being raised from $750 in arrears to $1,000 in arrears. The other thing is some of these provisions, so that one in particular was currently applicable only in Baltimore City. The bill is generally expanding most of these thresholds and protections statewide. So you see that there in lines 27 through 29, as well as 30 through 33. Current law does have a prohibition on selling certain residential property and then other property that's exempt from taxation, which is religious use property, when it's only consisting of charges for water and sewer service. That is being refined on the residential property component to be limited to owner occupied property for that protection. And then you'll see an amendment down after line 33, which would authorize jurisdictions to withhold from sale non-owner occupied residential property. Taxes and arrears consist only of a lien for unpaid charges for water and sewer. And then this subparagraph 2 also requires that the property meet objective criteria established by either the city or the governing body of the county or municipality. That provision you'll see in existing law under subsection E, which is also being expanded statewide. That provision allowed property to be withheld if it was designated for redevelopment purposes. And when that provision was passed by the General Assembly, because it was in the nature of an authorizing discretionary authority, the legislature added that language about the property meeting objective criteria established by the governing body. The idea being that when that authority is being exercised, it's being exercised uniformly and transparently. And so since this provision related to water would be in the similar authority, added that there for your consideration to include. The next change of substance is regarding the interest rate for property redemption. You'll see this on page 6 of the reprint. When the bill came over, the language stated that for owner-occupied residential property, the rate of redemption is 10% a year. I've spoken with my counterpart over in the House. The intent there was that that language say may not exceed 10%. So the 10% was meant as a cap, not as a uniform rate amongst jurisdictions. And that's also only applicable to owner-occupied residential property. On page 7, you'll see the bill for the timeline for filing a complaint to foreclose is extended from 9 months to 12 months. And then you have another 3-month extension related to owner-occupied property down below. Other changes on the next few pages are expanding certain provisions that are limited just in the city to be statewide provisions. So provisions related to abandoned property reverting to a jurisdiction. And then the last item on page 11, this is 14.849.1, currently is a statute related to sales related to water and sewer charges. This section currently only applies in Baltimore City. The changes under the bill, consistent with expanding the other tax sale provisions to be statewide provisions, expand this to the entire state, not just Baltimore City. And again, it makes that distinction between owner-occupied residential property and non-owner occupied residential property. So if you go back to page 2, we've cross-referenced here so that those two provisions work in harmony. The general effect of this is that within Baltimore City, would be narrowing it, those protections to the owner-occupied residential property, and for the rest of the state, it would be implementing these standards for both types of residential property. There's still the prohibitions on selling on the owner occupied residential property as well as the religious properties.
Senator Alfred.
Thank you, Mr. Chair, and thank you, Philip, and I appreciate the conversations we've kind of been having over the last few days since we had the bill hearing. I think I understand the perspective of the amendment that's kind of been at question here of there needs to be a mechanism for the city to collect on its water bills. I think that's something we all could agree with. It's a question of how do we also protect the renters in those circumstances, and perhaps I could ask DHCD, can you walk us through like a case study of how this would work, and what is a safety net for a renter should a non-owner occupied house go into tax sale? If that's okay, Mr. Chair.
And Senator, I would note, one thing that gets confusing on this topic is the terminology tax sale.
Okay.
So a tax sale is the local jurisdiction when a property has taxes and arrears, they offer it up for auction. What's purchased at that time is a certificate that gives the certificate holder an opportunity at a later date, subject to certain procedures, to then file to foreclose and then take ownership. So when the annual tax sales happen every year, no ownership interest is actually transferred at that time.
That's really helpful. If I'm, Mr. Chair, if you could just walk us through what this looks like for an average person here. You don't touch it. Don't
Don't
touch
touch.
it.
No, okay, good, thank you.
Thank you.
So if you wanted to actually walk through from soup to nuts, I'd actually direct you over here to Joshua from SDAT. What I would like to do is just kind of echo what Phil was saying, is that and I've had conversations with several of the members of the committee specifically about this portion. You know, what are the protections specifically for renters, right? And with this amendment and this change here, you know, Phil's exactly right. You go to tax sale tomorrow. You have someone purchases that property, that certificate. I'm sorry, not the property. They still have, and you'll see in the bill here, we're changing that foreclosure date from 9 months to 12 months. They would still have a year before any action can be taken place. So if the renter is even in for a month or two and with a 1 year long lease, they still have 10 more months on their lease plus 2 more before they were to go to actual foreclosure on the property to hit it. That's if today we did it. We went right to sale and the municipality decided they'd given enough notices and they jumped into it. We're already in that situation right now. I'd also point out that with the existing mechanism as it's set up, if I'm a property owner and I'm sitting on an asset that's worth $150,000 and I've got a lien against my property for water of $3,000, $5,000, $10,000. The old saying, you know, don't let a penny hold up a dollar gets in the way there, where I would be incentivized as an owner to pay that off before I'd let it go to tax sale and lose that actual, you know, that property that I've got, the equity that I've got in that property too. But if you want an actual walkthrough from soup to nuts, I'd like to actually bring in Josh here to talk about that.
Yeah, so I really don't have much more to add. I think that's a pretty good representation of the timeline. Essentially, from when you are delinquent on your taxes, you have a year until your property can even be considered to enter tax sale. Say it was sold on that date, then it would be another year before that property could actually be foreclosed on. It's a timeline that tends to exceed what your general lease would look like. Renters' protections, generally, when a property changes hands, do and can still apply to people who are renting. So they can't just be kicked out of their homes on the day of. They also have 30 days notice requirements and other protections established in state law to make sure that they're not.
Yeah, I'm sorry, Senator.
Thank you. It's a really helpful explanation. It just occurred to me though, how do we ensure that the renter is also notified that that 1 year clock has started? So there's nothing in this bill that says a landlord has to share that information with the tenant. So if I'm a tenant and I get a notice of foreclosure, even though it has been 11 months of this process, there's nothing that says I've been notified. So I'm just trying to look out for any curveballs for our renters.
Sure, and I'd also like to point out, and I was remiss in the beginning of not saying this, is that in Baltimore City, participation in the Water for All or promise pay automatically exempts anyone from tax sale for water liens alone. So that's already existing in the city. So even that adds another layer of protection on top. And when we're dealing with this, I think that the biggest issue here is the city, that if they're pulling those out automatically, plus they're adding in that extra amendment to say, we want the ability, the may, not shall, on non-owner occupied. We feel like that helps kind of add that buffer.
And again, I'm completely sympathetic. We cannot have a water system if people aren't paying into it. I understand that. Would DHCD or SDOT be opposed to something on this bill that says that if someone has entered into a tax sale, it's sold, they have a year worth of foreclosure, that has to be communicated with the tenant at the time that happens? Would there be a problem with that?
I defer to the wisdom of the committee. Right, so we have no objections to something like that, for sure.
Thank you.
Yeah.
Thank you, Mr. Chair.
And just to clarify one thing, there are also reporting requirements in the bill that properties that enter tax sale or tax sale foreclosure those records have to be kept by the local jurisdiction for at least 3 years and reported to our tax sale ombudsman. So.
Senator Corbin.
Thank you. Just trying to clarify a little bit and piggybacking on two statements that the senator to the left of me said about, we talk about the protection of municipalities and the water systems. So with this now, Philip, basically whether you're owner occupied or a renter,
Talking to you.
that could be pulled from the tax sale if there's a lien because someone hadn't paid the water bill. Is that pretty much what these amendments and all this stuff does here now?
For non-owner, currently, the water restriction applies to any residential property.
Okay.
That could be single family home being rented. That can also be a, multi-unit apartment complex.
So now we're gonna add in the non-owner occupied, is that what you just said?
Yeah, the bill with the amendments clarifying would allow each jurisdiction
So what,
the authority to do the non-owner occupied for water, subject to adopting criteria for doing that.
I guess back to the thing with the municipality and the proprietor of the water, how do we get the water bills paid, I guess is the question. That's not a question to you per se, well,
So
where
if
is,
it's part of the tax sale process,
Right.
the purchaser of the certificate for that property has to pay anything outstanding.
no, but I'm saying if they don't go to tax sale,
Mhm.
they hold them from tax sale, the water bill still hasn't been paid. It's not going to tax sale, so what do we? Like, that's just feel like we're stuck in this revolving circle then. Where is, I guess,
Generally, it can be a lien on the property.
right,
And so, even though it wouldn't be collectible, to the extent it's not collectible in the tax sale, when that property, if the owner would try to transfer it, that lien would have to be
Right, but I think-
satisfied, but that could be a long period of time.
exactly. Do we know? I appreciate JCB, but do we know where like MML and Mako and those folks are? Has anyone heard from them since the amendments and stuff like that? I don't know. Any of those folks here? Oh, you're here. Where's MML with this? No, not you. He's back in the corner.
Generally not in favor of that one provision for an ability to collect, but.
All right, so. Okay, thank you.
Senator Hellman.
You, Mr. Chairman. So my understanding is that once there is an exercise of the right to redeem, then the lease could be kaput. Is that correct? The lease no longer holds once there's the right to redeem has been foreclosed.
I would have to check on that. I do believe that the once the property is redeemed, you mean in terms of being taken out of tax sale, or once the property is foreclosed on?
Sorry, foreclosed.
Gotcha, understood. Yes, there are certain protections to still make sure that the renters on day one can't be kicked out.
And what are those?
They still have, I believe, 10 days to vacate the property once the property is foreclosed on.
Okay, 10 days, but we give like in a mortgage foreclosure, we give 90 days, right?
Right.
And we're gonna give 10 days here.
That's not listed under this bill. That's what I understand to be in current
Right.
law.
I guess I'm still concerned. So
You're not gonna find it, I don't think, in the body of the bill, but current law 14,836 B412 requires a plaintiff in the foreclosure action to send notice to each tenant of the subject property whose identity is known to the plaintiff at the tenant's last reasonable ascertainable address. So that's when the action is filed.
Right, but again, like Senator Alfred said, there are times where we're not ensuring that the tenant is gonna get notice that this is even going on, right? So if we can,
I mean, the notice, the section does provide the notice shall be sent by certified mail, posted, prepaid, return receipt requested. And be accompanied by a copy of the complaint. The plaintiff shall file on the action, the return receipt from the notice or an affidavit that the notice provisions have been complied with. Or the address of the holder of the subordinate interest is not reasonably ascertainable. I think in the instance of a tenant in the property, they should know where they are. I think that where it's not ascertainable, I think is relevant to other ownership interests.
right, but how is that information shared with the potential purchaser, right? This is somebody from the total outside coming into this process. How is it that they're gonna even know who the tenants are and have the ability to contact them?
Yeah, I'm good. Yeah, for sure.
Do we know?
I'm sorry, the potential purchaser.
Right. Right, isn't it, you're saying it's the potential purchaser that has the obligation to notify?
No, the purchaser of the certificate.
Purchaser.
That's what I'm saying, like the terminology is confusing. So like you're purchasing a certificate that gives you standing effectively in court to
Right.
file that foreclosure action.
Right,
It's the same entity. Once it's foreclosed, that entity who purchased the tax certificate then gets title to the property. That would then be a subsequent transaction. But and like, well, I guess technically a tax sale certificate can be transferred, but the requirements in law are that when the court action to actually foreclose on the property is filed, that notice is given to any known tenant of the property.
so but that can be many months in, right?
It could, yeah, and I mean, under the bill, the action wouldn't be able to be foreclosed until 12 months after the property is auctioned.
Right, I'm just trying to think of the timeline here. So I have a lease for a year,
Mhm.
right? And so presumably maybe, I don't know, in month 11, I want to re-up my lease because it's coming up.
Mhm,
And so that is when that process that you just walked through happens.
mhm.
So what happens to me if I'm the renter there? So I'm expecting and hoping that I can stay where I've been and I want to re-up my lease. I have no idea that this has been going on. All of a sudden I get notice that this has been going on and I have,
After you've renewed.
right. So I'm out of luck.
I mean, I would defer to the departments on how those protections work. Again, that would be subject to the foreclosure actually happening and title being transferred.
Yeah, I mean, that would sort of, that would assume a very fast foreclosure process.
Well, but it's not fast because it's a year, right?
No,
Under
that is
this
year
area.
to file,
A year to
That's to
file,
file.
yeah.
then it's got to go
foreclosure
through
action.
the court process.
Okay.
Right. So you should know between the filing of the foreclosure and the actual action being taken by the court. Before you know that motion is, or that court filing has been made well ahead of the actual final action being taken. So we're not talking, and that 2 years, by the way, is like the most truncated time frame you could possibly have under this bill. So again, like taxes are delinquent, you have another year till tax sale, you have another year till the foreclosure action is filed. And then between the filing of the foreclosure and the foreclosure actually taking place, will likely take months.
Okay. All right. Okay, thank you.
Any further conversation on this bill? I have a question. I'm sorry, because I was up and down. I'm not repeating anything. I had a legal question actually about contracts. Yeah, I have a feeling you might give me that look. My question has to do with the requirement of a purchaser who would ultimately foreclose, and the requirement to honor a contract, a lease contract, with a tenant. Do you have any knowledge about that?
So I think that's what you were talking about earlier, right? That once the actual foreclosure process happens, that can break the lease, and that's when you have the 10 days. Is that correct?
Yes.
Yeah.
Okay, so, right, it is, the lease can be broken, but at foreclosure essentially is where
It has to
is-
complete
is-
foreclosure, yes.
Right.
but not before.
Correct, because the ownership is still, it's still the owner.
With the original.
Correct.
Okay. Thank you. Anything else? Yep. Mr. Boston, did you have something you want to add?
Yeah, to your question, under contract law, if it's like assuming Frank Boston on behalf of the law firm of Hyde Candy and the Tax Sale Purchasers Association. On you stand in this, under contract law, you stand in the shoes of the person you're assuming their rights are. So therefore you have to honor that contract.
Gotcha.
And they're right, foreclosure takes way over 2 years before it from soups to nuts.
Right.
Yeah.
Let's do
And in
someone
some
else.
cases, in terms of tenant notice, the property is posted. So
There-
you would assume the tenant would see the property being posted. It's posted on the,
On the door?
yeah, in rem law.
Okay. Okay.
Did you have something you wanted to add?
Yes, Mr. Chair, we've got Matt Hill, Public Justice Center.
Why don't you step up?
Thank you. In a normal sale and in a mortgage foreclosure, that's correct, that the lease survives the sale. The lease, the purchaser steps into the shoes. That's not the case for a tax sale foreclosure. The tax sale foreclosure, when the right to redeem is foreclosed, forecloses every other interest in that property so that the purchaser takes free and clear. And so that lease is terminated.
Right.
And then to the point that the only protection is that 30-day notice to all occupants. So it's not even addressed to the tenant. And my clients at times receive that, at times they don't. And it's 30 days, not before an action's filed, but before the sheriff shows up at your door. So it's 30 days and then the sheriff can be there on day 31. And so it's very different from mortgage foreclosure, which again has a 90-day time frame and so forth.
But the process itself has been going on for, Mr. Boston, you said 2 years, right?
Yes.
At least.
Is that, would you feel that's accurate?
Yeah, yes. The problem is from my client's perspective, tenants in the property, they're often like, they may have just gotten into the property 6 months ago. So they weren't there 2 years ago when some initial notice came out to the renter. And so they're taken completely by surprise. Even if they're not taken by surprise, the owner is still the landlord. They still have ownership of the property, as Mr. Cook said. And so the tenant owes them rent. And they're still bound by that lease until that interest is foreclosed.
Let's not lose sight of the fact that 97% of properties are redeemed. Only 3% go all the way through the 2 years plus foreclosure process. Most properties, tenant and non-tenant, commercial, even vacants, are redeemed. 97% are redeemed. And it's 10 months, and then you start to file the right of foreclosure, and that's, to the gentleman's point, that's when you file. You don't get in circuit court right away. So it's well beyond 2 years. Yes.
Senator Alfred?
Thank you. And I'm sorry, I missed the gentleman.
Matt Hill, Public Justice.
Okay, Matt, thank you, Mr. Hill. You bring up an excellent point, and Mr. Boston, I appreciate the notice on the door. Philip just showed me the law about a letter that is return requested and all that, but I think it's our job to think through every worst case scenario and ensure that no one falls through the cracks. And so to Mr. Hill's point, what if a process started today and I'm the current renter and I get the letter, but I move out in 6 months, someone else moves in? What is to ensure that new tenant also receives the notice and that they are read into the situation at hand? Or do you have an idea for how to solve that particular problem? Realizing it might be rare, but we have to think through the scenarios.
You're
Okay.
saying if a new tenant, tax sale process is, I don't know, a year and a half into the process. And a new tenant moves in,
Right.
unaware of what's going on. Yeah, I don't know the answer to that question. I would have to get an answer to it.
Do we have to say maybe perhaps it needs to be disclosed by the owner or the landlord when entering into a new lease with somebody? Would that be a proper protection? Would you be opposed to that?
Could be, I mean, yeah, I agree that tenant should have notice, nobody wants to see someone kicked out on the street.
Right.
And yeah, I mean, we get that, under that scenario, yeah, that 6-month tenant who's only been there and has no idea should know something.
Okay, thank you.
Yeah.
Thank you, Mr. Chair.
Okay. All right, any other questions? All right, we're just gonna hold this for now. Thank you all very much. Appreciate it. 4:52.
House Bill 452, the primary, triple E is primary on this bill. This bill is identical to Senate Bill 675 as it passed the Senate. It's a departmental bill that requires the State Board of Individual Tax Preparers to publish a code of ethics for engaging.
Are they in the same
It's
posture?
the same posture.
Okay, and we've already voted on this?
Yes,
Was it unanimous in committee?
it was. It was 11-0 in triple E and. I gotta check for whether or not I believe it was unanimous in committee, but I don't think it was unanimous on the floor.
It was unanimous. And it was unanimous.
Okay. All those in favor? Opposed? Okay. Nobody needs to do that one, though. Although I want you to be prepared for it, Senator Roosevelt. 534.
Actually, you already did that one, I think.
Yeah, we did that.
It matched the Senate bill. So actually 534 and Senate Bill 90, you all have Senate Bill 90 back from the House on a concurrence message. These bills were extending the
So we're in the same posture.
well, not necessarily. Let's do the concurrence first and then
Okay.
we'll get you there.
That's right.
Senate Bill 90 was extending the Live Near Your School program and a related homebuyer assistance program to 2030. The Senate bill had a provision, it was a May, authorizing the governor to provide funding for the program. In the House action on Senate Bill 90, the House struck those related funding provisions. And so basically the Senate Bill 90 as amended by the House is just an extension of the programs. So those are the amendments before you on Senate Bill 90 for consideration.
Senator King.
What does this bill actually do?
Under the House amendments, it just extends the program by 4 years. It's a
What do you get if you live
it's-
near your school?
yeah, so it's a program to in sustainable communities to provide current students and recent graduates with financial assistance in the form of grants to buy homes near the school attended by the student or graduate. And then there's also a homebuyer assistance program authorized by the Community Development Administration that's also being extended along with it. And they can assist current students and recent graduates to receive low interest mortgage loans. So it's basically home buying assistance
Okay, so
for,
it doesn't have anything to do with where a child's directed to go to school.
No, this is for, I think the idea is people come here, we're trying to keep them here. You know, come here for college or grad school.
Yeah,
We're trying to help them stay here. I think
Okay.
that's the concept behind the programs.
Okay.
Under the House
We had
amendments.
this on the floor last time.
Ooh,
this is such a.
I think it was Senator Roosevelt.
No, don't even go there. I don't think it was, but I don't remember.
I just wish it had a different title because it is such a sensitive issue with parents that,
Mm-hmm.
yeah.
No, I knew you knew how to find it.
And it still is Senator Roosevelt.
Yeah, Bill gets out of committee.
That's right.
So I mean, the program's already in existence. This is just an extension. It's extending the sunset.
Okay, so we're voting on the Senate bill first.
Correct.
All those in favor?
Right.
Opposed? And then on the House bill,
House Bill 534 is identical to what you just concurred in.
all those in favor?
Right.
Opposed? All right, all those in favor of Senator Roosevelt doing this bill? Aye.
Thanks. Thanks for your confidence.
Absolutely. All right. 6:30.
Okay, House Bill 630, as introduced, this was a joint committee on pensions bill, cleaning up provisions related to Title 37 transfers of service. First change, it was correcting an erroneous reference to the
Is
member.
it the same as our bill?
No. You should have a reprint on your desk.
Everybody start with that from now on, so I don't even have to ask. If it is, just let us know.
This one and the next two will have amendments.
Okay.
Thank
goodness.
There was also the bill was dealing with, so under pension law, there's a 5-year requirement when you transfer to get the benefit of the new system calculation. The Joint committee heard testimony and the system testified, nobody does that, it's kind of obsolete. So that was being repealed. There was a provision related to the retirement systems that was not included that you all added to the Senate bill. The House missed that. So the amendments are adding that in. There is an additional issue being added by amendment. During the session, it came to the attention, so our executive director and HR brought to our attention, there was an issue with some DLS employees who have started contractual and remain contractual well beyond the normal policy for being contractual. They're currently converted to permanent employees in the system, but they have substantial amounts of contractual service, which should have should have been earning. So when you're a contractual employee, you're not enrolled in the pension system. So none of that contractual service counted towards their current credit in the system. So the amendments in the reprint before you would provide a pathway for that to be rectified. So to be eligible to receive the eligibility and service credit under these amendments, an individual who is employed by the Department of Legislative Services, they need to be continued to be employed on July 1st when the bill takes effect. They needed to be employed by the department prior to the effective date as a contractual employee, with the contractual employment exceeding 5 years, and then who has not been employed by another unit of state government after first being employed by the department. So I feel like it's fairly narrow, and it's addressing this issue where the contractual service is substantial but exceeding the general policy for using contractual employees. The bill also provides, gives them a window to reach out to the department to apply to receive this credit. They would be responsible for making up the missed employee contributions. So while they did not receive the benefit of having that credit, they also were not making the employee contributions that all the other members of the system is. So to keep everyone on an even footing, they're required to make a payment for those contributions. However, if they don't make that payment, their account will have a deficiency on it, reflecting the actuarial value of those missed contributions. And that's something that's common in other areas.
I can think of no one better to handle this than Senator Jackson. What do you think, Senator Jackson? You got it? All right, then they're going to change our bill presumably.
I will coordinate with House staff.
All those in favor as amended? Opposed? Senator Jackson. 768.
It'll be easier. 768 is the bill establishing the disability, line of duty disability benefit for judges. The House did not do the amendments that were needed, and so the amendments in the reprint before you just conform House Bill 768 to Senate Bill 604 as passed by the Senate.
Conform it to the Senate.
Conform it to the Senate bill. They add the amendments.
You
that
had
were-
me at that. All those in favor? Opposed? Is this yours, Senator Gorman, isn't it? Okay. 850.
850, this is a new bill. There is an amendment.
No
This-
new bills. We don't want any new bills.
This is a procurement bill. It would expand the small business preference program to all executive branch units. And then also take out University System of Maryland and Morgan State. And then requires the Board of Public Works to implement and oversee the program. This is a program where it's like a price preference. There is an amendment. So you all and the House have actually passed unanimously Senate Bill 673, which in that bill, it was creating an outreach program for small businesses and the Small Business Reserve Program. And then also changing what is considered eligible to count towards the small business procurement targets for each unit. In this bill, in the reprint, you'll see on page 5, under 141502E, they added in this bill similar requirements about that calculation, but the wording is different. And so the amendments before you strike that section because it's already being taken care of in Senate Bill 673 and its companion House bill, which are already passed unanimous for both bodies. So the amendment avoids the two bills conflicting with each other. The substance of both is the same, so having it in one bill is fine.
So again, this just allows this program to apply to all agencies.
It allows this program to apply to all agencies, and the amendment strikes provisions that would conflict with the bill that's already on its way to the governor's desk. That does the same thing as the bill that's already passed to the governor. It's just
Okay.
worded differently.
All those in favor? Opposed? No, please.
So I heard you say Morgan, University of Maryland, College Park, but I don't know if the system was already in the bill or like
They were currently in under current law. They actually, there was testimony, they
already doing
want
it.
to be out. They asked to be out of this. They're already subject. to
So basically saying all our public universities, and that's why Morgan and College Park is the one you singled out.
They were currently specified in current law. They asked to come out of this, but then everything, it's being expanded to everyone else. The current law, it's just DGS and MDOT.
I just want to make sure it applied to
And
everybody.
those two entities. So it'll apply to everybody, but those two universities will come out.
Okay, you're saying those two as not to be. in
Correct.
this. Okay, all right, but every other one.
universities are in.
No, current law is DGS and MDOT, University System of Maryland and Morgan State. The bill strikes all that and says any unit or agency of the executive branch of state government.
I got it now.
And so that carves those two universities out. And should apply to the other universities in the system.
I got distracted there for a second. What? Who's?
They're currently in, the bill takes everything out, it says all units of the executive branch, so it takes them out. Those two, higher ed institutions.
Including all the other universities,
no. All units of state government, not the universities.
not the universities. So now none of the universities are in.
Correct.
Okay, I
I just want to make sure. it's-
I got it.
My understanding is that's what they want.
Okay.
That's what the sponsor indicated to me. And this
Okay.
is just the preference program, not the small business reserve program.
Okay, all those in favor? Opposed? Senator Jennings, you're just looking like you need a bill.
Oh, absolutely.
You really don't? You don't? All right, then Senator Stallings, you need a bill? No. Would you like to be?
He said he'll do it.
They're fighting over it now.
Wow.
JB's got it? All right, JB's gonna do it.
You came close, Johnny, right?
All right.
You were almost at it.
I love it when you're fighting over it. All right. Nice. 903.
Okay, this bill is not identical. There's a reprint on your desk. This, to remind you, this is the bill that for,
IEPs.
mhm.
IEPs.
Yes, going through the process and giving them access to attorneys or advocates to assist as they're going through that process. So this is different than what the Senate bill did. The primary differences on page 8 of the reprint, Tripoli voted this, and so these are amendments that they did this yesterday, I believe. In line 26 on page 8, they're specifying that the advocate would be getting compensation for providing those services. Then on page 10, for the entirety of the bill, you'll see, as you guys saw it, it would have been the Maryland Volunteer Lawyers Service administering this program. This is now switching to the Legal Services Corporation. There's some additional words here in terms of it adds some responsibilities of them in the middle of page 10. And then on page 11, it authorizes them to basically work with another nonprofit to do training for these advocates. The important thing is on page 13, this reprint is based on the amendments done downstairs, but there was a verbal addition to that, which was in line 10 on page 13. The House bill came over with a $2 million annual appropriation that is being struck. They did this verbally to be $1 million, which matches what the current budget has in it. And then finally on page 14, there's the reporting requirement for data collection, and they're adding some additional data that needs to be collected.
So the line item we have in the budget,
Mhm.
is that in the right place now? That because it goes to the fund and not to Maryland Legal Services?
Correct. Within this bill, it creates a fund, and that is drafted to go to the fund. So what is written in the budget is agnostic as to who might be administering this program.
Okay. And who's going to administer it now?
So under these amendments, it is switching from the Maryland Volunteer Lawyer Services to the Maryland Legal Services Corporation.
And they administer it by providing legal services on their own when it's a legal action.
No, this would be, they would establish like a client list of students and families who are going through this. And then they would also establish a provider list of advocates and stuff that they can do. So I believe the intent is, you know, someone would apply for these services, a family, they get matched with someone who would then help them out. And then this fund would provide for reimbursement to that individual. And there are existing provisions in here about the capping the reimbursement amount, capping the total amount that a student could take advantage of that amount through their life.
So the fund actually pays the parents?
I'm gonna put my words on the language since we are 7 days in. So the fund is used for.
And just so everyone knows, this has been through so many machinations, it's not even funny. We're just trying, because it's unclear who was running the show and who wasn't. I think everybody agrees that we want this to happen. We want people who need legal representation to get legal representation, but we also want the advocates, which is the primary purpose of this, the advocacy, right? It's 75% of the fund goes to advocacy and 25% would go to sort of legal remedy.
So correct and correct.
Okay, so I think this is right. We're gonna dig one more check with Ross after we do this.
I already did that.
Okay, good.
The thought
So
there's.
we're good as of today.
There is a floor amendment that he will be preparing, but he didn't want to hold up this.
I got you. This has been something else to get this right. All right, so, okay, so we're anticipating a floor amendment.
Correct. I'm not sure what that is. going to
Yeah,
be.
I mean, it's all about getting the right people to administer. It's $1 million. We got that. We want folks to have this ability to use this resource to help with their children and going through an IEP process. But so I guess there may be one more thing to happen, but I'm comfortable personally voting for this now. And I've actually been paying a lot of attention to this over the last couple of weeks. And it's going through so many dips and turns. But I think we're in a good place, and whatever the floor amendment is, I'm hoping it's just going to be relatively minimal.
See if he's.
Yeah. Senator King.
Yeah, I just have a question. If I am a parent of a student that needs services, is this going to be the one way that I go to get those services, or will I still be going through my local school system? Is there going to be one way for people to get services, or are there going to be different ways? Because that, to me,
I don't think this changes the
doesn't.
services. This changes your ability to have advocacy as you go through the
Right.
process.
okay, but is there one place to get that advocacy, or is it going to be in other places?
I think it will be administered through one source.
Okay,
But there
'Cause
may
I'm
be,
looking at
but
the
there are
amount-
people who do this all throughout the state now,
right,
provide this advocacy, and you pay for it.
sure, but I'm
Um,
looking at what the school systems are paying now for that kind of stuff, and I just don't want to have them having to be paying gobs more for us
This
doing
is
this. I mean,
the-
it's all something that needs to be done, but there's also a limit to how much funding the school systems have. That's what I'm concerned about.
Yeah, I mean, I think this is for a group of students, and this is all still at an income level, right?
Did they keep that? Yes, they did keep that.
So this is so right now, if you have a student that needs these services, you can hire the appropriate advocacy people and you can pay for it, you can get it, but some people just don't have the money to do that.
Right,
And so this is what's helping those individuals
Okay,
to get that same kind of. Okay. Senator Hedelman?
And this change is from MVLS to MLSC. MLSC is fine with it because they actually don't provide legal services. They provide grants to organizations that do. So they are good.
I believe this is right. We'll see what this floor amendment looks like, but at the end of the day, we know, I know this much, that we do know the answer.
Yeah.
And the answer, when we get out to the floor, if it's slightly different.
No, I think this is, I sat in on the committee hearing and I think that this is a really essential service that would be provided through this program. So I wholeheartedly agree. It's a good thing. Thanks.
Thanks. Senator Benson.
I think this is long overdue. However, I want to kind of piggyback on what my wonderful friend across the aisle here on the one that's there on the corner. I want to piggyback on what she said. You know, as a former school administrator, there's a process that we follow when we find that there are children who have issues that are centered around disability. We have a person, we have pupil personnel workers, we have psychologists. The school system have certain personnel workers who come into the school to sit down with the administrator. There's a process, and then they do what is called the mediation, where they bring the parents in. Is that still in place before you move to this attorneys and all that other stuff here?
So, Senator, as I understand it, at this point in time, anybody can bring in their own advocate, right? Through the process that already exists in all the school systems, right? They would bring in that advocate to help them
Mediate.
to get the best out of the process for their child. This is just allowing for something to be set up for individuals who are on a lower income to be able to have that same opportunity to have some sort of advocate to walk them through the process we're not changing the process that exists in the school systems.
That's what I'm after.
I mean, just so everyone knows, the reason that this came about in this way is because for a number of years, we had a bill about burden of proof. And that burden of proof is what the school systems was really concerned about, because that would have changed the cost to the school systems in a dramatic way. And that's what folks were worried about in the school system. This is an answer to that, to basically help individuals who are lower income get the same sort of representation that other people who may be able to pay for it can have.
So the process doesn't change.
That's correct.
Thanks.
Senator Jackson.
Yes, thank you. As you were speaking earlier, I looked at, I found the household income not to be more than 150% of the legal services core income guidelines, which was one of my questions initially. Secondly, the reporting mechanism that's established, is that in the legislation as well?
Yes.
And who, and if so, who they report that to?
Yep, let me just find the language here.
Right here.
So on page 14, the Legal Services Corporation has to collect the listed data. And then each year, the corporation will compile that information and then report it to the General Assembly.
Got it. Thank you.
Senator Zucker.
You're much, we're secondary on this, right?
Correct.
I'd move favorable.
All those in favor?
Aye.
Opposed? Okay. All right. House Bill 918.
Okay, so House Bill 918 is also not identical. You'll recall this is the one that changes the membership for the state treasurer, and in a couple instances swaps in the comptroller for it. What the House did is, when it initially came in, it was doing this for 4 groups. The House struck the Maryland Environmental Services, so no change under the House bill will be made to the membership of the Maryland Environmental Service. Everything else is identical to the Senate bill.
Was I was the floor leader on that. I was just trying to remember. So was the environmental service the one where it wouldn't be have representation by either the treasurer or the comptroller? Or was this one that was?
Let me look. It would return to current law because it's struck from the bill. And current law is.
Just the treasurer. Just the treasurer.
Yeah, just it is.
Right. I would move. How does the treasurer feel about it? I'm sure he's happy to be off 3, right?
Yeah, I mean, I think it's reasonable, given the concerns we've seen with the Maryland Environmental Service, at least not to change anything at the moment.
Move favorable.
All those in favor? Opposed? Senator Zucker. 1012.
I don't think that's right. I'm not aware that this came out of Triple E yet.
Is that right?
Yeah.
So.
Thank you, Senator. Everyone agree with Senator Jennings?
I always do.
Yeah, I do. So we're gonna hold that. 1064.
1064 is the same as Senate Bill
Holy cow. We'll take it.
897.
All those in favor?
It has an amendment though.
Oh,
Only makes it an emergency measure.
okay. Yes, absolutely on this one. Yes. All those in favor as amended? Okay, who had this before? Jack, did you have it? Yeah, that's right. Yep, Bailey. Yeah. Okay, 1082.
Okay. Senate Bill 1080, House Bill 1082, there is no crossfile. This one effectively does two things. It alters the dates for when the AIB is. No, okay. Substantively, what it does is current law for the blueprint is that local school systems need to appoint a implementation coordinator that's responsible within that system to implement the blueprint. What this bill does is it adds mandated funding of $150,000 for each county to salary and benefits for these coordinators. And then it stipulates that that funding amount needs to be split between the state and the local governments in the same proportion, so therefore wealth equalized, that the foundation aid is. So it is a shared cost between the county and the state. Roughly that's 50-50 across the state. So that comes to $1.8 million for the state and about the same for the counties. There is currently a $2 million budget add that the House put into the budget bill for this for fiscal 2025. But then the mandate would continue thereafter. The next part of what it does, you've already seen this in a different bill, even though it's not cross-filed with this, is for the dates that are required for like the AIB to hire the independent contractor to report on how it's doing. Those dates are all accelerated that are identical to how you all have already done that in Senate Bill 1102.
Questions? Absolutely. You may. Did you have a question? We are holding. Well,
1212, this is new, it was not cross-filed. 1212 would establish a director of diversity, equity, and inclusion in the state retirement agency. And then the bill also codifies the governance programs in the state retirement agencies and investment division regarding monitoring, evaluating, and quantifying risks related to environmental, social, and governance factors related to the investments. There is a reprint on your desk. There were some amendments requested by the system, and the amendments basically clarify the process. So first with the new director position clarifies that that's a position within the state retirement agency, not the state retirement and pension system. And that position would report to the agency's executive director. The other two more substantive changes would be related to the termination process for that director position and then the governance program position. The process there would be require a recommendation by the executive director to the board and then a vote from the majority of the board of trustees to remove individuals in those positions. As introduced, the bill had language stating good cause, which is a difficult standard to administer and not really found elsewhere in state law. My understanding is the sponsor is comfortable with the amendments.
questions? How are we feeling about this? Senator? All those in favor? Opposed? Senator Jackson. Backed up by Senator Jennings. 1334.
House Bill 1334 extends indefinitely the continuing the core partnership fund in DHCD and establishes a funding requirement for bidding in fiscal 26, an appropriation of $50 million annually. According to the fiscal note, currently the program is supported through capital funding.
Everybody understand this one? It's important to work on some serious housing issues.
Second.
All those in favor? Am I correct? Oh, you're no? Yes, sorry, I apologize. 1334. Okay. Yes, because you said that. Senator McCray. 1390.
I'm checking the finance.
Thank you.
Yep. Okay, House Bill 1390 is also not cross-filed, so it's new. And it is heavily amended. But it has to do with public school construction. Multiple things. First of all, it's initially the Safe Schools Fund was supposed to, it would be repealed in another year and go away. That was initially envisioned in the Built to Learn Act. However, this is repealing that repeal, thus making the Safe Schools Fund permanent. The next thing it does, it makes some alterations to the P3 authorization that Prince George's County has. Specifically, it adds a provision that has to be in the MOU. It alters the deadline, actually it removes the deadline by which the P3 must be started in order to get the availability payment from the state. That payment is accelerated by a year. My understanding is that the special fund where that exists currently has that money, so that does not have a fiscal impact. It is just doing it in 2025 instead of 2026. The next thing it does has to do with the, what is this? Another fund that was created by Built to Learn was the Public School Facilities Priority Fund. This one was going to deal with, air conditioning, heating, plumbing, other major problems. Initially, that fund was going to start in 2027. That still remains. However, the uses of the funds are kind of specified in 2027 and then a bit more broad in 2028 and thereafter. On page 7 of the bill, it also actually reduces the annual mandate for that fund. Current law was 80 million. It reduces it to 10 million. Then there's some provisions from prior laws. You'll remember that when the Built to Learn was passed, or actually, yeah.
It goes from 10 million, from 80 million to 10 million.
Sorry, it goes from 80 million to 70 million. It reduces it by 10 million. Thank you. I did see some looks. I was like, what did I just say? It clarifies that, so current.
Hold on. What's going on there?
Can you just read the bill or what was amended?
It was amended by the House. So I'm going through the amendments to describe what the bill does because it is many more numerous things were added into it that weren't in there as first reader. Correct. Well, it's on the floor system. It's not a reprint. The House added a lot of things to the original version. Yep. So there is language here. You'll recall there's a goal basically in state law that the 450 million needs to be provided for public school construction. And this specifies that any funds through the Built to Learn shouldn't be included in that goal. So it's like a supplantation, not supplantation language going on there. And then actually it also reestablishes, but with a different membership, the work group on assessment and funding of school facilities. That was created and Built to Learn to kind of put a priority in terms of so it reestablishes the issue is that the data that work group that was initially created needed was very much delayed. That data, IAC has now figured out that data, and so the work group would now have something to work with. So it reinstates that work group with a report due to you all. Oh, and then there's a provision that gives priority for Prince George's County to give priority to a High Point High School for the next major projects list that they have.
Okay. Mayor Benson.
Okay, thank you. I have an amendment that I would like for the committee to consider, but there's just a little problem. I have not had the opportunity to speak to the sponsor, the delegate Harris, about this amendment. But I'd like to pass it along for you all to take a look at. And Mr. Chair, if it's okay, we'd like to see what the possibility is of us acting on this bill tomorrow, contingent upon the conversation that I would have with Delegate Harris.
So we're gonna hold this bill anyway, so
You gonna hold it?
we're gonna hold it.
I'll tell you.
And then I want to pass the proposed amendment to the attorney.
I'm sorry, too many.
Gonna hold it.
conversations. We're gonna hold this. So you have plenty of time to deal with what you need to do better. And on this side.
Okay, this is the proposed amendment. Did you see?
Right, we don't have.
We did not want the.
He doesn't want it?
I know, but this is the first we've seen it.
No.
Okay, that's not what they just told me. They told me to talk with him and he didn't have a problem with it.
Senator Heller.
I have a question, because this is really the first time I'm taking a
Hold on, I
decent
need to
look at
answer.
this. Does this decrease funding for the school construction program for the rest of the counties? In any way?
Mm-mm.
It does not, even though it says it reduces the mandated appropriation for the Nancy Copp School Facilities Priority Fund.
Let me see. And since you're holding it, I can certainly come back to you with an answer on that one.
Okay, thank you. Thank you.
Well, if we're gonna hold, I'll.
So. Everybody get your amendments together and we'll just load this thing up.
This, what I'm not talking about is this language that Jack wanted to put into the budget.
I
And
understand.
we were told then to just tack it on to this bill.
That's fine.
Yeah.
I'm fine. I understand.
Mm-mm-mm. I'll have to check across the street and see what the rationale was. Well, it's a fund that hasn't been used yet. It had a delayed effective date until fiscal 2027.
We got more to do.
Well, that was in
Don't get too excited.
fiscal 2027, so
We
there
got
is
7
no,
more after this, I think.
there's no,
I know, it's shocking. We're being nimble. The end of the season. Yes.
I am, I heeded your message on the floor. You should have a couple letters should have been, in Miss Erica's, she has. Thank you.
I just got word that finance voted the court bill. They were moving on about 5 minutes ago. I'm gonna tell her next.
All right, well, let's finish what we got. So we got 1486. 1486.
Yep.
We've got very important bills before us, yes. Really important.
House Bill 1486. This is out of finance. It is identical to the Senate bill that you passed earlier.
Right.
Move favorable.
All those in favor? Aye. Opposed? All right, that ends the normally scheduled programming. But we have a number of bills. We're gonna start with one that just came hot out of finance. This is the port bill. Port of Baltimore. We're second on this bill.
You got his stuff?
Yes.
And you got the vice chair.
Senate Bill 1188.
Senate Bill Senate Bill 1188 establishes 3 programs to assist the employees and businesses affected by the closure of the port. You have a reprint of the amendments. The amendments create a fallen transportation worker scholarship program for children or spouses of the fallen workers. It increases the revenue bonding cap for MDTA to $4 billion. The last amendment, and I'm sorry, I'm literally just getting these amendments. And the last thing that this amendment does is establishes benefit payments for the family members, and it excludes it from the adjusted gross income of those family members.
There's some questions for you.
One is there any detail on the Fallen Transportation Worker Scholarship Fund? I mean, what is it or how would it work or?
In the reprint, it begins on page 2 of 4, which would be, I guess, the 3rd page of your reprint. It explains what it is. It's
Oh, there it is.
the spouse and children of the fallen workers are eligible for tuition assistance. They may attend a 2-year certificate program. Must be at least 16 years old, and the child, stepchild, or surviving spouse of the worker.
I now see it. I get the drift on to qualify. The thing that I'm interested is what it qualifies for. I don't see the certificate language. Where is that?
It is on. It's the top of.
Undergraduate, graduate, or professional program and out of Wednesday.
I'm sorry, could you say that? I can't find it. So say that more loudly.
On page 4, section 2, number 1.
Number 1. Temporary laid off is what I see as number 1. I'm sorry.
I think it's the case.
I'm sorry, 3. My apologies.
Okay. A 2-year terminal certificate program in which the coursework is acceptable for transfer credit or private career school. I mean, very frankly, I sound like a broken record, but I mean, I really think this should apply for certificate programs that aren't 2-year, aren't terminal, and well, they'd be terminal if you finish up the certificate, but it's acceptable for transfer credit. I mean, there are lots of ones that would not be acceptable for transfer credit, but are good training for a good job. I'd really like to fix that if there's not objection from other committee members.
Yeah.
Do you mind if I just comment on what Senator Rosepep said? We're second on this. So my thought would be if it's the wisdom of the committee to just let it out as it is, and then we can communicate with the committee of jurisdiction to see if there are entertain other amendments that we can amend on the floor. But I think if
no, I'm happy to do it on the floor. I'm not trying to slow it up. I did a very important bill, but that's what I'd like to do is to see if we can work out some language to make sure it's broad enough to encourage folks who are not going the whole route.
Okay.
Okay, that was number 1. My second question related to the bonding capacity. Again, just kind of, it takes, as I read it correctly, it takes it from 3 billion to 4 billion. Is that the essence of what it does?
Yes, it goes to 4 billion.
And I mean, it's obviously whoever carries this on the floor, and I'm not volunteering, Mr. Chairman. Whoever
we don't have to.
Oh, that's right. I say Triple H to do it. You're right.
Well, how about finance?
Or fine, we have finance do it. JPR is okay with me. My only point is that I would like to understand what the significance of that is, why we're doing that, how that works, et cetera. I know how it works, but I think Senator Elfith knows.
I know why the number is the way it is. This is at the request. We all received a letter on Friday from MDOT requesting that lift of the cap from 3 to 4 based on the bridge incident. So that it was a request directly from the MDOT secretary.
I mean, is the implication of that they're saying this would cost $1 billion? Is that, I mean, do you have any idea how they came up with the number?
I don't know how they got the number.
Okay. I mean, I think that's something we should pursue. Just so we understand. I mean, that's why we do the review on the fiscal side here in the committee. Those are my questions. Thank you, Mr. Chair.
Jennings.
So this transportation worker scholarship program, so this is new.
Yes.
I just, almost 13 months ago, we had another 6 workers killed on 695.
It didn't include that.
Oh, okay.
Right.
Includes, it's
Okay.
comprehensive. That's the point.
That's what I'm trying to find it.
Yes, they're included.
All right.
What did they do for those workers?
We're doing the same thing.
This is it.
This is it.
This is a really good thing.
And I heard you mention the dollar figure, 4 billion.
That's for the bonding cap. Yes.
Okay. And this bill does nothing with anything with regards to anything being capital side, like dredging or anything, correct? Because we have an issue we're dealing with in the district.
This bill is specifically for the businesses.
Okay,
and
just making sure, confirming that we're not dealing with any
individuals.
dredging issue in this bill.
They're for it.
Yeah, just want to circle back to the scholarship. Make sure I'm interpreting this correctly. When it talks about, who's eligible for it and the amount, it says here, I guess it's that third page, it's underneath where we were talking about the 2-year certificate thing, but it says it may not exceed the equivalent annual tuition. But then underneath that it says, but be less than $3,000. So is it basically saying it's a $3,000 scholarship? Because that doesn't seem like a whole lot to me. I mean, the way that I'm interpreting it, unless I'm wrong, that would basically kind of cover community college, but if you went to a 4-year institution, it would only pay up to $3,000 to that 4-year institution.
This may not exceed the equivalent annual tuition and mandatory fees for a 4-year institution, and then
What we're gonna do. We're gonna hold right now on this.
Okay.
We're gonna get the person who presented over here.
Okay.
Because it seems like we got a lot of questions. And we're gonna move on to the remainder of our calendar, our special extra calendar.
They're voting right now. Yeah.
Okay, what's the next bill? Pick an easy one.
Pick an easy one. All righty. You've got 2 bills. Can I have my mic on, please? Thank you. You have 2 bills that are cross files, are identical, are local to Somerset County, and you now have a local letter.
Okay, What are they called?
Yeah, sorry. The first one is House Bill 976. This is for Somerset County for appropriations for their fire companies.
Okay, all's in favor?
Aye.
Opposed?
The next one is House Bill 977. This is also for Somerset County for the sale of a certain property on Rebels Neck Road.
All's in favor? Yeah, I remember that one. Senator Bailey can take both of those. Oh, you did? Well, I would want you to have that then. Both of them will go to Senator Jennings. Good point. Thank you, Senator. Are you here for the port bill? Yeah, we're waiting on the analyst over in finance to come over. If you would prefer to wait for that, or you can try to give it a shot one way or the other. You ready to go with it? Okay, let's try. Okay, we have a myriad of questions, actually. What was who had the scholarship question? You did?
One over there and one over here.
Okay.
Mine was simply related to, I wanted to broaden it to make sure that it applies to non-degree, non-college tracks, workforce, certificates, apprenticeship costs. Clearly.
That's the intention. Well, there's language in there that we copied from a different scholarship in the code that includes a reference to schools that are career schools.
That's different.
Yeah. I think that's a policy decision for the committee, but we're perfectly.
Yeah, if we could work with you on the language, I think our hearts are in the same place, but I think the language needs to be a little clearer.
Yeah, I mean, I
Well,
defer
what
to
we were planning on doing is voting this out, assuming we can get it out of here. And then if there's any amendments that members here would like to do, they can present on the floor.
Sure, and Senator, I expect that there will be other conversations that happen even after the bill leaves the Senate, and we're committed to working with both sides on, I presume there will be further amendments in the House.
Okay,
thank you.
Senator Quarterman had a question also about scholarship.
On the it's talking about the amount, it just wasn't clear, and I quite possibly it's probably gonna be misinterpreting it. But it talked about for the scholarships that it may not exceed the equivalent annual tuition of a four-year institution, but then also says be less than $3,000. And then after that, then again, it also says equivalent. I don't know, is it double negative going on there, or is it a $3,000 scholarship, or is it the full amount of tuition?
It's as I read it, it's a minimum $3,000 scholarship up to full tuition.
So minimum 3,000 up to. Okay, thank you for the clarification. Go ahead.
And that language is taken directly from the Crier scholarship language.
Okay, so we say minimum, I guess that's what I heard you. Who makes that decision as far as where it just depends on what the institution is based on what the amount is, or?
Ultimately, it would be subject to the availability of funds, which is
Okay.
a budget question.
Okay. Thank you.
Yeah, hold on a second. Yeah. But that doesn't have anything to do with the rainy day money.
No.
It's a separate.
There's nothing in this section of the bill on the scholarship. The scholarship would be funded as are other scholarships through future general fund appropriations.
Okay. Yeah, right. No, wouldn't be much at all. Yes, Senator.
My question on the increasing the borrowing limit for the MTA.
Yes.
From 3 billion to 4 billion.
To provide MDTA the flexibility it needs in case it needs it related to reconstruction of the bridge, because it's really just a flexibility thing.
No, I mean, I get the intent, but I'm trying to get, why is it 3 to 4 instead of 3 to 3.5 or 3 to 5? I'm trying to understand where the numbers came from.
That's a question ultimately for MDOT, and I can get in touch with them and try to get you a response to that as soon as possible.
I'd like that. Thank you. Thank you.
Senator Sullivan.
I think it would be good, first of all, if everybody would like to amend themselves to the bill.
No.
And at the same time, move it for favorable.
Senator, I just can't thank you enough for including us. I would say let's not mess with the bill right here. And if we're going to do anything, let's do it on the floor, just because.
Yeah.
But that would be wonderful.
Okay, so everybody want to be on the bill?
Yes.
All those in favor as amended? Opposed? Very good. Actually, you know what? Hold on. I know we need to vote it clean. We need to do without that amendment, unfortunately. Yeah. Hopefully we'll all get amended on the floor, maybe. We can all get amended on the floor. All right, so as non-amended.
Yeah, why not?
All those in favor?
Aye.
Opposed? Very good. Was it? Yeah. Yes.
When we allocate money as senators, the individual must attend a school in the state of Maryland. In this particular program, with the allocation of the scholarship to the youngster, that youngster has the opportunity to go to school anywhere in the country? Or is the scholarship confined to the state of Maryland?
Do you have an answer for that?
What'd you say, Mr. Chairman?
We're checking.
Oh, okay.
Huh.
So
Maryland? They have to go to school in Maryland.
4 years, 2 years unspecified.
Yeah, I know that's 4 years, but I was just wondering whether or not if a youngster wants to go to school in California or go to Pittsburgh.
We're checking.
Will the scholarship be recognized in Pittsburgh or California, wherever this
They
youngster
probably
goes?
will give an equivalent amount of what a 4-year college in Maryland
Would
would.
it have to be a 4-year college in Maryland?
The rate, I would guess, but I don't know. That's how some of our other programs work.
The bill?
Let's get it right.
Sorry, Mr. Chairman, just pulling up the link.
Take your time.
it uses a term of art, but I just want to double check the definition of that should make it just give you the state.
There's language in the bill that says an individual may apply to an eligible institution of post-secondary education, which I believe is defined elsewhere in the bill as being an institution within the state of Maryland.
It would have to be in Maryland.
Yes.
Thank you.
Sorry, elsewhere in the statute, not elsewhere in the specific bill.
All right, thank you very much.
You might want to consider like an equivalency, like the 529. It's a thought.
It might be worth further future consideration. I'd suggest that if you do that, you'd want to consider it doing it for the Conroy and the Cryer scholarships as well, because they are similar scholarships, particularly for the children of veterans and children of fallen law enforcement officers. You'd want it to be applied evenly.
Yeah. Yep.
Yeah. So it, as was pointed out, it uses the term institution of post-secondary education, which is indeed defined. Double check and make sure it's with that section. And it basically says a school or any other institution that offers educational program in the state for individuals who are at least 16 and who have graduated from or left high school. So it could be community colleges, could be 4 years. But definitely in the state. But I want to check one more thing.
And I just suggest, Mr. Chairman, I think there's some interesting policy questions the committee's raising. I think it's important that this bill move quickly.
Yeah.
And obviously we'll have chances further down the road to explore some of those policy questions in more depth.
Yep.
Department of Commerce and
No, this is separate. This money, so this program is created, the scholarship is administered by MHEC. So it'd be an MHEC's budget request next year.
thank you.
Okay, so we're passing it just as we received it from finance. All those in favor?
Aye.
Opposed? Okay. Very good. Thank you. Thank you. All right.
Got from F's,
For what?
send them on to you
For what?
for this bill.
For the bill we just did? Okay,
I'll send them to you.
okay. All right. Where were we on that, on the other list? Did we get through one? We got through a couple of those Somerset bills.
Correct. So I now have two bills from Prince George's County. Kim. Thank you. So I have House Bill 396. You do have a local letter. It is for Prince George's County. It enables the county to use certain proceeds from a local sales and use tax on energy to meet their funding requirements for K through 12 education.
All those in favor? Opposed?
Then you have House Bill 398, also for Prince George's County. You also have a letter. This one authorizes the county to impose an excise tax on telecommunication services, capped at $3.50 per month. And that this then would be able to use those revenues also for K through 12.
All those in favor? Opposed? Okay, Senator Jackson's got those too.
That one was House Bill 398.
Okay,
You want me to bring up this one? They just emailed me today.
yeah, let's talk it through.
Okay. The next one is House Bill 66, again, not a cross file. What this one does is three things, but what the three things have in common is they are all local property tax credits, and the counties and municipalities are authorized to provide them. So what the three are is, first of all, residential real property that is the primary dwelling of an employee of the public school system, and the dwelling is in the county where they teach. The second one is an apartment building or condo if the owner made health or safety improvements to the building after July 1, 2024. The third one is an apartment building or condo that's used on or after July 1, 2024 for purposes of local housing programs for homeless individuals or families. All of the details of the credits are left up to the county to establish.
What was the second one?
The second one was apartment or condo if they're making health and safety improvements to the building.
Health, safety. So what's that?
It is all the same bill.
66.
Mhm.
So initially I was a little sort of just taken aback by the concept that there were these, we typically deal with these one at a time, these kind of opportunities. The delegate, side has chosen to put three different things in one bill.
Sorry. Go ahead.
I presume, I don't know that we've really had a chance to look at, do we have any existing law that is similar to any of these three things?
Depends on what you mean by similar. I'll have to do a scan of all this whole title. There are some.
Okay, so I would like to see that.
Okay.
To see if we're overlapping in weird ways. So we'll hold that. What else we got? Anything?
I have two messages from the House on Senate bills that they have amended. The first one is Senate Bill 321. This is the property tax credit for hotel and residential redevelopment project. As the House amended it, it matches the House bill, which you all have already passed and has already passed third reader.
Is it statewide?
Yes. Yep.
Okay.
It's authorizing for a county or municipal to do this,
To do, and what is this again?
to offer credit.
Uh-huh.
It's a credit for for property that is used for a hotel or residential development. That's newly constructed.
Yeah.
To be qualified for it, if it's a hotel, then they need to substantially increase the assessed value of the property. If it's a residential development project, it needs to include at least 20 units and have at least 15% of those units be affordable housing for people that earn less than 80% of the area median income.
Okay.
Effectively, and also this is the one that has the Wacomico County had this, and this bill expanded to the whole state. If you remember when you guys voted on the House bill, the only difference was they did some wordsmithing and reorganization, but substantively they were identical. So what they did to the Senate bill is just put it in the same structure with the same wording.
That's also the bill we initially had for municipalities only, and then we also did the I'm sorry, that's a tourism bill. Too many amendments. But it's a good bill, so we're favorable.
Okay, so I'm sorry, what did the House do to the bill?
They reorganized and reworded some provisions, and it reads easier than the Senate bill version did.
That's it.
That's it.
It's technical.
Yeah, sure.
Okay, all those in favor?
Aye.
Okay, opposed? And then, so are we taking that to the, what do we do?
No, that would be a
the
simple concur with the
concur?
House amendment.
That's what I thought, right?
Yep, so that's usually you.
Yep.
Okay. I have the same thing. This
Yep.
one is for Senate Bill 616. This is the Maryland Historical Trust with the Museum Assistance Program. They amended it to be, again, identical to the House bill, as you all have already passed the House bill.
Yeah.
I think it's been through second reader on the floor, but not third. What they did is current law basically says that if you're going to get this museum assistance program, you can't get it if you're also getting a grant from the State Arts Council. So the House struck that provision of current law, thus enabling a recipient to get funding from both programs.
Okay, so move to concur. All those in favor? Opposed? Okay. Is that it?
That's all I have.
Anybody else? What you got? You got local? Okay.
House Bill 835. This was not cross-filed. This is a local Calvert County procurement bill, which would authorize the county commissioners to enact an ordinance that would give a percentage preference to a resident business submitting a responsive bid over an offer by a non-resident business. We give a local Calvert, or authorize Calvert to enact an ordinance to give local preference for resident bidders against non-resident bidders.
Okay. All those in favor? Opposed? Senator Jackson. Yes.
It was where allocating Garrett household 5%. We're waiting on letters for that. Right?
Yes, we are.
Okay. Thank you. Delegation letters or.
I need to know that the senators from those districts are in support of it. Sorry, not me, you.
Okay, I think that's it. So I think we can shut down.